Good afternoon, everybody. Chris Gantt-Sorenson and Katie Busbee here, and Keely Yates, Director of Marketing of HSB. Reason why we're able to actually come to you via webinar. And we're here to talk about independent contractors and the misclassification issues that run into relationships that employers believe are or intend to be independent contractor relationships that won't be viewed that way by the agencies who are determining investigations into any claims that it is not an independent contractor relationship. So this is like a really big deal. It's always been a big deal in employment law, misclassification, and use of independent contractors for relationships that otherwise are probably employment related, continues to be risks for employers. That's not new. What is new is there is an increased focus on this issue by all three agencies who have something to gain and who it's their purview for investigating these types of things. And that's the reason that employers need to be more aware of this and more vigilant. You know, it's something that Katie and I, or anybody who practices employment law, has been running into forever. But there's greater reasons now for employers to comply. The risk for misclassification are significant. And, now's an opportunity to really streamline and make sure that it's something that's prevented rather than having to be dealt with after the fact when the damage is already done. So we're excited to talk to you about it. It could potentially be a boring topic for folks who aren't interested in it. But hopefully those of you that signed up are actually intrigued enough to be able to slog through all of the boring mire with us, because we are going to go through the standards and we'll provide you with the slides afterwards so you have it. And I've also got a tool that I've asked Keely to send out to all the attendees that I use every single time I talk to employers about this issue from the IRS. I've used it for years, and it's a great analysis tool for you to use in your workplaces to determine whether or not you think you have a potential misclassification issue. So with that being said, we're going to get started. And of course, we're full service. We've got law firms in 5 office locations across the Carolinas. We also have, and I'm involved in a number of cases with folks in other states. We have a mutual relationship, mutual agreements where we assist them with things in our state and vice versa. So we've got further reaching than just the Carolinas. If you've got Q&As, drop them in the Q&A or the chat. Either Katie or I will answer those live or in chat. So make sure you're keeping up with the chat as the seminar goes along. We try to answer everything that comes up during the seminar. If there's something that we're not sure about, sometimes we'll take it outside, but you're also welcome to email us if you've got anything that wasn't discussed or answered after the fact. And let's get started. So we're going to talk about the IRS, DOL, and the NLRB. IRS, obviously everybody knows what that is, Department of Labor and National Labor Relations Board. The most recent guidance that's come out on independent contractors from the Department of Labor came out March 11. It's been in effect since then. NLRB had something come out last year. I believe that's right. Katie's going to talk to you about that. But recently, IRS, it's been clocking along, has always had something. So this is not new. But I put IRS first because circuit, which is our of appeals, is our jurisdiction that will oh, somebody is saying they lost sound. Katie?
Yes, for a minute, but you're back. You might just want to repeat the last
So sorry.
couple bullets.
So sorry.
You're good now.
Okay, good. Each of the 3 agencies, IRS, Department of Labor, and NLRB, have their own test. And I always think this is to keep the lawyers in business. It can be the only reason. Because each test is different. Each test focuses on different things. But my belief is if you comply with the IRS test, that'll take care of the test in the other 2 agencies. Additionally, the Fourth Circuit Court of Appeals, that's the jurisdiction that all of the employers in North and South Carolina and a few other states come under. It has its own test. And then every other circuit also has its own test. So this is a complicated issue that requires analysis on the upfront to make sure that you can keep yourself out of a misclassification dispute. A lot of companies will say, oh, don't worry, we have a contract, we have a written agreement. Well, every one of these agencies, and including the court, is going to look behind the agreement. They don't care what you call the employment relationship. So a written contract does not remove the risk. Also, even if the individual themselves wants to be an independent contractor, they have no interest in being an employee. That doesn't matter either. All right. So next slide. All right, what's the liability? You know, a lot of times I have clients when I'm talking to them about this, you know, they're like, well, what's the big deal? What's the big deal? What can happen to us? Well, it's significant. You can owe back taxes, federal and state, back FICA from the date that the relationship was established up to present for the length of the time that that matters. And you know, a lot of times these self-employed folks and or individuals who want to be independent contractors haven't put together that they're not going to qualify or it's not going to help their Social Security, their FICA. And so they'll bring this stuff up after the fact. So it's important to remember that that might have been going on for a long time. Then you have the liability for the economic value of the employee benefits that were not provided to the contractor. You know, whatever you're providing to your employees as part of their employment, 401k match, if you've got pensions, health insurance, dental, vision, HSAs, disability insurances, anything like that. And if it's going to be employee specific. So, you know, if it's someone who would have been properly classified as an employee who seeks a disability claim and determines, oh gosh, I don't even have disability insurance, but all the employees do, you can see where that goes. Workers' compensation, unemployment compensation, these are things that pop up. And then also looking back to how many hours did this individual do work to perform the duties of the contract? Well, guess what? You weren't tracking their hours, right? They're an independent contractor, so it's whatever they say. And if they're exempt or non-exempt, first of all, if they're non-exempt, then it's all their hours plus any overtime hours. And if you as the employer don't have any hourly records to refute it, i.e. they haven't submitted hourly records to you, which is what we'll tell you not to do if it's if we want to show that it's an independent contractor relationship. But if you have no hourly records, the DOL will take the employee's word for it. This I know because an investigator has told me this before, and that's what they do. Same with bonuses and overtime. You know, if there's any non-exempt employee who's misclassified as an independent contractor, you're going to have to overtime for that. That'll be up to 2 or 3 years, depending on whether or not they think it's willful. And then there's civil penalties, lawsuits, possibly class actions. In fact, typical cases like this bring a class action with them because it's a typical compensation, wage and hour claim, and those are typically addressed in the form of class actions. So a lot of risk associated with this. Next slide. Department of Labor. So we'll start with them since they're the most recent. As I said, they went into effect on March 11, 2024. This is not unusual. The test alternates back and forth depending on who is in the executive office. And so this was going to happen. The economic reality test that only looked at the opportunity for profit or loss to the individual and their control over the work, that has now been replaced and gone back to the totality of the circumstances test that's always going to be in place when there is a Democrat in the presidential office. And this test, under the DOL's interpretation of it anyway, is an analysis of 6 factors and any additional factors that are relevant to the economic dependence of the employee. So an employee is someone who is dependent on the employer for work, right? So this is a crucial analysis of the person that we're looking at the contractor. Is this someone who is able to earn money from other places? And it's tricky when we think about gig workers, right? So that's the nuance here. Factors that do not have a predetermined weight and are considered in view of the economic reality of the whole activity. The Department of Labor says we're not going to consider any factors as more important than the other. It's going to depend on the situation and how it impacts the economic reality. In other words, you can't rely on any of the 6 factors to be the most important. No single test means they'll figure out a way to determine whether or not. And remember, they're probably geared to look at this as an employee relationship. So it's up to the employer to prove that it is not. And this test, the Department of Labor's test, was changed in order to capture gig workers. All right, so next slide. The DOL's test, 6 factors. number one, opportunity for profit or loss depending on managerial skill. So what that really means is this someone who is going to be able to make more or less money depending on how they manage the project? Independent contractors are typically seen as folks who are brought in to handle a specific project. And they are typically seen as someone who has a skill set that the business or the employer does not have within its own employment, own employees. And so, or it's not something that's part of what the business is of the company. You know, it's electrical repair on the hospital, right? This isn't part of what we do, you know, so we have to have somebody come in that knows how to fix the electrical components of the hospital. In that situation, that is someone who's bringing a special skill set we can't replicate. No one in our company is performing the same duties. And that person is quoting us an overall fee. And depending on how they manage it, they have an opportunity to lose money or gain money. So that's what this means. The relative amount of investment made by the worker. If, again, we'll use the same analogy, we're bringing an electrical expert to come in who's going to deal with something specific in the hospital. They have special tools. They have money. They've put money into the stuff that they need to do to carry out the services they're supposed to perform pursuant to the contract. The permanency of the relationship. Well, we don't need this person longer than it takes to remedy the problem we have. It's a serious problem. It's an indefinite time period, but it is expected to end when the services are completed, and the services are, you're going to repair this big quagmire, electrical quagmire we have going on. The nature and degree of our control. If we are saying we need you here from this hour to this hour, we need you to follow the advice of so-and-so and so-and-so. We, you know, starts putting parameters of control on time that the days the work is performed, the hours the work is performed, the way the work is performed, the processes that are employed, you know, and having to report every single day and be, you know, supervised by someone. That's control. Versus I get to come in whenever I want and work whenever I want, and I get to do the work how I want. You know, and in my analogy of a hospital, we can see where there would be value in coordinating off certain times that we would want work done that might impact electrical systems. So we could exercise some control there, but it would be, you know, are we exercising control elsewhere? And how much control? The other thing is, as I mentioned, is this person that's come in with a special skill set doing the work that's also being done by people who are employed by us? Typically, this is aligning with actually the business of the entity. You know, is this part of what the business of the entity is? And do we have employees doing the same duties that this contractor is coming in and doing? You know, that's going to lead itself to an employment relationship, not independent contractor. And then again, whether the worker is using specialized skills indicative of business-like initiative, not my words. So next slide. All right, these are some observations that are directly quoted from the rule because I think they show you how vague this rule is. That's the reason I did this. I still think there's ways to work around it, so not to worry. But they focus less on the actual exercise of the control and the opportunity for profit and loss as the core factors than in the economic realities. And if you remember, the test as it changed over the last couple of years was also that even if they did not exercise control, did they have the ability to do so? So that is something that has to be considered now, whereas used to, you only considered did they exercise the control or not. Here, they could actually not exercise the control and still be responsible as an employer if they could have. The Department of Labor says the mere fact that a worker earns income from more than one employer and does work for multiple companies may not in all instances indicate independent contractor status. So there it is. That's a gig worker criteria. So we can have people who are gig workers who do work for a bunch of different people. It's not going to automatically mean that they're independent contractor. If the company's control goes beyond legal compliance obligations and into compliance practices of the company, it's going to be a factor that the DOL will see supports an employment relationship. So if you think about that, that makes sense, right? The company has obligations legal compliance obligations in the industry, and then just generally in regards to its own employees and how work is done. You can expect your contractors to follow those regulations and those requirements. We're now talking about regulations, industry standards, those sorts of things. But if you also are requiring your contractors to follow your written policies, that are not written in compliant, in direct tie to these, industry standards, then that's going to militate in the factor of an employment relationship. The person who is investing capital into their business in order to perform the services you need are more likely going to be considered an independent contractor. Rather than showing up, you provide them the tools, you train them on how to do the work. And if they're entrepreneurs, i.e. they have created this electrical business to come in and provide these abilities, and they have bought the tools and the resources to do so, and they have themselves obtained the certifications and the trainings that they needed to be able to perform this level of electrical work, then this is going to more likely indicate an independent contractor. Oh, and then I mentioned retained or reserved control that is not exercised is still viewed as the ability to control. So next slide. Why do we care? Gig workers. Sorry, a bit about gig workers. They're on the rise. Y'all know this. We get more and more questions about gig workers. When Katie and I touched very briefly on this issue back in our legislative update, the questions that came in were about gig workers. So I think in terms of gig workers, again, case-by-case analysis is always what's going to be done. But some of the things I think you need to think about is short-term work versus sustained work, even if it's sporadic, because I think about the issues with Uber, right, and Lyft. And if people have been doing it for years and years and years, how is it that turned into, and granted, a lot of it was where the litigation instituted, out in California, but how is it that turned into independent contractor, employment relationships? What happened? And I think that it was a number of things that could easily happen. Because someone who's driving gets to choose when they're going to do it, right? So that looks like control. But if we're starting to implement policies around it, how you do it, we are requiring compliance more than how you operate your car and that your car has insurance on it. We might be stepping into it there. The more that we work with someone, the more that it's no insight in period, no definite time period, the more that it is along the lines of what would ordinarily be part of our normal business operations, i.e. we're a food delivery service, but we use Uber. We offer delivery, but we use Uber instead of our own employees. You can see where this is going. You look at all of those factors together, and you're better off if it's short-term projects versus sustained work. That's just the obvious one to me in light of everything else being equal as far as how a gig worker deal works. Again, also who's bringing the tools, right? Who's made the investment and how they do their job, how they know how to do their job. If it's an entity that offers specific services and they advertise as such, is that some of the factors that we're going to get into through the IRS, those sorts of things are going to start to lean towards independent contractor. But gig worker is particularly difficult, and it's actually going to be based upon the specific relationship, the specific jobs that you as a company are using gig workers for, and how those are being handled and documented. Next slide is the why do you care slide. The Department of Labor is looking to see where you have not given benefits to the independent contractors that were misclassified, same as you would have given to your employees at the time period in question, as well as lost wages. And we talked about all of those: unpaid minimum wages, possible overtime, liquidated damages. In the Department of Labor world, that's FLSA, that's 2 times their back wages or owed overtime. In South Carolina, that's 3 times under our South Carolina Payment of Wage Act. Always attorney's fees in that situation, and monetary penalties, and then any other like profit share or anything else you do for your employees. This is going to be something that you have to be making right with people who've been misclassified. Plus, if it's profit share into 401ks or any sort of investment, then you're going to have to give the an additor for any sort of growth that they lost for not being included for the number of years they were. All right. I'm finished talking about the Department of Labor.
Okay, I'll take it over from here, Chris. National Labor Relations Board issued a new decision last year in June, the Atlanta Opera decision. And as Chris mentioned, anytime we have a Democratic presidency, we get decisions that are very employee friendly. Anytime we have a Republican presidency, it's more employer friendly. So it's not surprising to see a new rule come out from the NLRB. In this Atlanta Opera case, this involved the Atlanta Opera, who contracted with makeup artists and wig artists, hairstylists to perform work for certain productions that they were doing. This group of workers brought a petition to unionize, and Atlanta Opera said, you are independent contractors, you're not employees, so you're not protected by the NLRA. So next slide. So the NLRB looked at, are these individuals truly independent contractors, or are they employees for purposes of the NLRA? And so they set forth a new test that looked at, a lot of the factors that we're talking about today. There's a lot of overlap. This particular test, they set forth 11 different factors to look at. And so I'll quickly go through those. The extent of control by the employer. Control is something that through all these tests over the years usually is a hallmark factor, maybe less so recently, it sounds like, but it's still a factor. Whether the individuals are engaged in a distinct occupation, how unique is it what they're doing? Is it very distinct, very skill-based? That's going to lean towards independent contractor. Whether the work is usually done under the director of the employer or by a specialist without supervision. How much is that employer overseeing what they are doing? The skill required, whether they are providing their own tools or whether the employer is providing the tools to be able to perform that work. Next slide. The length of time for which they're employed. Is this a very, very long agreement where they're doing multiple things for a long time? Is it short and more project-based, which it should be if they're an independent contractor? Method of payment, are they being paid by the job? That would lend more towards independent contractor. Whether or not the work is a part of the regular business of the employer. Whether the parties believe they're creating an independent contractor relationship, whether or not the principal is a business, and whether the evidence tends to show that the individual is in fact rendering services as an independent contractor. So that last factor is basically saying, the NLRB is going to look at all the facts taken together to determine whether this person leans more independent contractor or employee. Next slide. So in looking at this Atlanta Opera case, the board looked at how these hairstylists and wig artists were performing their work. And they said that these people were actually employees, so they were protected by the NLRA. And some factors that weighed in favor of being employee, they found that Atlanta Opera exercised control over their day-to-day work and gave a lot of feedback and instruction. So, their production managers would hire these people and they'd give very specific instructions on how they wanted hair and makeup done and costumes and things like that. So they were very closely regulating what these people were doing. The opera also provided the necessary equipment for these people to be able to perform their services. And I think this is an important one, and one it discussed for quite a while, the decision. They were paid an hourly wage with the potential for overtime pay. So that sounds very much like an employee. Employees are paid hourly wages with the potential for overtime. So based on those factors, the board said that these people were employees. There were a few factors that they noted weighed in favor of independent contractor status, like the fact that these people performed very skilled services, distinct services. They knew how to do hair and makeup in a special way. Not everyone knows how to do that. And so that weighed in favor of independent contractor. And then also they had a lack of expectation of continuous employment. So the Atlanta Opera, they told these people, you know, you're being hired for this one production, and just because you're hired for this one production doesn't mean you'll be hired for future productions. In actuality, though, the board did note that most of the time Atlanta Opera was using the same people from production to production. So again, factors went both ways. This is kind of a sliding scale and a totality of the circumstances kind of situation. But, you know, if you have some factors that are weighing employee status, it's very easy for the NLRB to find that they're employees, because they really want to find that they're employees. These agencies do most of the time. Okay, next slide. So what are the repercussions for this? So the NLRB enforces the NLRA, and this can come up in a situation where very much like the people, the workers in this Atlanta Opera case, they are either trying to unionize, or they have, in, you know, that's less so here in South Carolina, but really what more happens here is that they're trying to engage in some kind of protected concerted activity, which is a broader definition than just trying to unionize. And, you know, they're arguing that the employer interfered in some way with that. And so they bring an unfair labor practices charge. And, you know, the employer, Atlanta Opera, in that situation might say, well, no, you're an independent contractor. You're not an employee. You're not protected by the NLRA. And that will kick off this review by the NLRB of what is the true classification of this worker. And so remedies that you can face, reinstatement, back pay, lost wages being the big one, informational remedies if you failed to post your required notices. But the NLRB did actually expand its definition of damages a couple of years ago to include any kind of direct or foreseeable harm that stems from the unfair labor practice. And so when you think about this, this would be things like, you know, if someone was terminated and they're arguing that it was in retaliation for bringing an unfair labor charge, or in retaliation for some kind of protected activity, and they lose insurance or they lose some kind of benefit, you know, all the expenses that stem from that, everything they have to pay out of pocket would be included in the damages that are owed. And so, again, this expansion of damages too is just a way the NLRB is trying to really kind of crack down on misclassification. Next slide. I think this is back to you, Chris.
IRS. And go ahead, Keely, click to the first one, but we have a question that I thought made good sense to answer live. And the question is, regarding control and using the employer's tools, how do big manufacturers like BMW, etc., use labor providers not have to count those individuals as employees? I assume that an individual working for a labor providing company would have to follow instruction from a BMW supervisor and would be using BMW tools while working. Absolutely true. So it's easy to get the independent contractor employee dynamic, or to think about it in the context of joint employer, but it's and temporary staffing employees. But it's important to also look at those two things separately, because from a legal standpoint, they are separate. So the analogy or the question that is brought up with the example, that is actually an example of using temporary staffing labor, and whether or not the temporary staffing company and the company that is using the labor are joint employers under the law. The tests are similar, in fact, almost identical in a lot of ways. But the analysis is more based on whether or not BMW, even though these employees are not their employees, and we're using BMW, I'm not speaking on behalf of BMW, I'm speaking to the analogy put forward, is whether or not BMW is going to be seen in the eyes of the law, whether it be under an agency analysis or litigation, as the joint employer of the labor that's being provided by the temporary staffing company. And some of the same things that we're talking about here today, which is it the normal business of the company? Are there employees working alongside, that work for the company alongside the laborers that are doing the same work? You know, is this necessary to carry out the company's business? Those are the factors in addition to, we can control what the employees do. We supervise them, we show them how to do it, the labor employees. Those are the factors that are considered joint employers. And I'm gonna tell you, it's really hard to, in a temporary staffing situation where you're really literally having same people come in and out on a regular basis, and they've even had some sustained working with your company, to contend they're not joint employers. So the way you handle that is obviously in your agreement with the temporary staffing company. That's the only way you're going to protect that, where you require the temporary staffing company to assume all employment obligations in regards to the labor that they're providing, and to indemnify, hold, and indemnify, defend, and hold employer, company that needs the labor harmless, to the extent that any of the provided labor or any third party contends that the company is actually the employer of the temporary staffing employee, right? So that's the analysis there. That's a harder fight to win. Independent contractor really is meant to be distinguished as someone who is coming in and providing a service to us as a true independent contractor. So, it is a different analysis. The damages also are the same in both of those situations, though, so they're very aligned. I can see why that question comes up. All right, so IRS's definition, it's more detailed than either the DOL or NLRB. And if you analyze it under the IRS analysis, then you are probably good under the two. The way that it comes up is if the IRS finds out that they have not been getting the taxes from you that they need. And even if you put into your independent contractor agreement, well, that's your responsibility, contractor, not mine. IRS doesn't care about that. They want their money and they'll come get it from you. And it's easier for the IRS to get money from a company than it is from an individual. The IRS does offer a voluntary classification settlement program, which presumably would have some benefit, although there could be an argument that then puts you on the IRS's radar. Next slide. And one thing, not just Social Security tax, but Medicare tax is going to come into play in addition to federal and state taxes with the IRS. So the IRS defines an employee as anyone who performs services for the company. When the company can control what will be done and how it will be done. Doesn't matter if they're part-time, full-time, or as needed, PN or PRN. And they have 4 categories of factors that have a bunch of subcategories under them that they consider: behavioral control, financial control, type of relationship between the parties. I'm sorry, 3 categories. Next slide. So we'll cover behavioral control first. Type of instruction givens. Do we tell them when and where to work? What tools or equipment to use? Do we tell them the sequence, the steps that they do to perform the work? The degree of the instruction that we give to the individual to do the work. The more detailed, the more likely it's an employment relationship. Does the company have the right to retain the control over the details of the performance? Or has it given up that right? That makes a lot of sense. An independent contractor that you're having come in and do work, all of us have had folks come and do our house and do stuff. It's up to them to do it right. And we can say, oh my gosh, you put in our countertop cattywampus, which, definitely happened to me. And you can say, you didn't do this right, and I'm not going to pay you till you make it right. But I'm not saying, look, when you do this, you need to apply this thing and you need to level it this way. You need to make sure it's level and you don't need to caulk it before you do it and all that stuff. That's a, extremely simplified analysis. Evaluation systems. Am I evaluating this person and letting them know, okay, you're doing this right, but you're doing this wrong. You need to do this better, right? And you could see where you would want to do that with a worker who is on site doing something that you believe is an independent contractor if you see they're doing it wrong. But you cannot really engage in that too much. And you certainly can't do this in writing or have some sort of established evaluation system. You train them. If you're training them on how to do the job, and if you want the job done in a particular way, this is going to be a sign of an employment relationship. Next slide. Financial control. Significant investment. I didn't give you all the subparts under these categories because they're similar to the sum that we've already discussed. But the independent contractor is showing up with stuff that they've paid money to come and do this job for. Unreimbursed expenses. I see still independent contractor relationships and contracts that are truly independent contractor relationships where the employer is agreeing to reimburse, the company, is agreeing to reimburse the independent contractor for expenses. This should not be. Those should be included in the overall quote that the contractor gives to the company for performing the duties. The only time that there should be expenses ever considered in a situation this would be so unusual or rare or unanticipated for the work. And it should be clearly stated in the agreement to this effect. Otherwise, that should not be. We should not be reimbursing somebody their gas and whatever other little expenses that would be anticipated to perform the services. Opportunity for profit and loss, we already talked about that. Services available to the market. So is this contractor somebody who advertises these services in the market? And then method of payment. And this happens a lot too. A lot of these contractors are being paid weekly, monthly, just like you pay employees. You know, generally, we're going to be recommending that we want you to do it by project. If you can't do it by project, then we want to recommend that you do it in a certain way that, you know, we've got recommendations about that, but ideally by project is the best. Next slide. All right, type of relationship of the parties. IRS considers that. Are there written contracts? Are there employee benefits? Permanency of the relationship. Services provided as key activity of the business. So written contracts, we're going to talk to you about what we think that looks like. But remember what we said, that won't get you out of anything, any sort of determination of misclassification, unless the factors also don't point to it by analysis under the factors that each agency considers. Employee benefits do not obviously offer any benefits to your contractors, and your contract should specifically state they're not entitled to them. Permanency of the relationship, the longer this relationship goes, the more likely it is going to be a factor that will militate in favor of the employment status. So, you know, typically somebody who's coming in and doing something that's not part of our business is going to come in and do what they need, and they're going to leave. That's short term. You know, I would say if you're starting to see continued work with the company over the period of time, and it's a sustained work, then you've got to make sure you're shoring up some other ends of it if that's absolutely something you have to do. You know, to have this company keep doing this, you're going to have to figure out how you make sure on the other end that everything else is pointing towards independent contractor. If the services are provided as a key activity of the business, i.e. your business is the business that this contractor is coming in and providing, you've got a lot of cards stacked against you in the misclassification bucket. And so there's got to be some explanation about why this is an area we don't have the skill set to implement. An example recently that I had was where an existing company wanted to create a separate department, a new department. It would be a new line of business for them. And the person, the consultant, was going to come in and do that. This consultant happened to also, you know, have other duties with the company that made it perplexing, you know, from an analysis of classification. But if this person has a skill set that would ordinarily be the skill set of your business, but you just don't have a division that does this, and you don't have anybody internal that can do this, and this person is only coming in on a consulting basis, and other factors line up, control and the types of things we were talking about, and this person truly is setting it up, then okay. But otherwise, if any contractor that is doing what is a key activity of the business of your business, then it's going to be an employment relationship. Next slide. All right, so the IRS currently has an 11-factor test. We're going to run through the analysis of those factors. The spreadsheet or the tool that we're sending you when we send you these slides is actually the IRS's old 20-factor test. It's a great way to thoroughly analyze the situation. That's why I still use that tool with clients today when we're thinking about these issues. So, does the employer have the right to control what, how, and when the worker does the work? Are business aspects of the job controlled by the employer? Written contracts, employee benefits, and is a key aspect of or integral to the business? Next slide. How the work results are achieved will be analyzed by the IRS. Are there job specifications, but no supervision or training necessary? The contractor was hired for the project because of the contractor's skill set, and the contractor figures out the methods to perform the work. The work's not essential to the company. You know, we keep beating this like a drum. The contractor's not asked to perform tasks during the work that is the business of the company. The contractor's not doing the same work the company employees are doing. They set their own hours. They're not on call. They're not on demand. They're not full-time. They don't work irregularly when work is available. Next slide. Payments. You're paid by the result, not the hours worked. You can make a profit or loss on the fees that you've charged, based upon what your expenses are. The contractors are responsible for their own expenses. They furnish their own tools. They have their own equipment, materials, or facilities. They have a significant investment. They've got some money put into the work that they're performing for you. And they advertise to the public. They have a business license. They have business signs. They have listings and directories. They have an office. They have assistants. Next slide. Control. The contractors are allowed to work when and for whom they choose. They can work for multiple firms. They are free to provide services to multiple unrelated clients at a time, and the company cannot restrict them from working elsewhere. So, you know, what that means is an employer, a company may restrict them from saying, you know, you can't go work for someone doing this work that you do for us if it's going to involve using, you know, confidential information and our trade secrets, but you can go do this work for other companies that are not like us. So without a case-by-case analysis, we're not actually able to fully analyze that for you. But if you are putting a non-competition provision in your agreements with your contractors, be on notice that you could have a problem and you need to consider ways to narrow that. Generally, you would not expect to see that. We would not be limiting a contractor from providing these benefits to other folks, other companies, even in the same industry as us. So there must be some special reason that you're needing to protect that. Some trade secret, some propriety information, some way that you can show it hurts you. Not just that you don't want them to give your competitors an advantage doing the same stuff they're doing for you. You can't fire your contractor. You can end the contract, but you can't fire them. So in your independent contractor agreement with this person, you say either party may end the contractor relationship this way, but you can't fire them. Next slide. Back to Katie.
Okay, I'll let you tackle the other questions, Chris. Okay, I was typing one out, but I didn't quite get to hit send, so I'll let you take that over. Fourth Circuit joint employment. So Fourth Circuit also has their own factors to determine whether entities are joint employers. And so this comes up in the context of when you're working maybe with a staffing company, or you have a subsidiary or an affiliated entity that employs the employees. And, you know, then the employee ends up suing both entities and saying, well, we didn't get benefits or get overtime through this other entity because, you know, their joint employers were supposed to be an employee. And so it kind of also goes hand in hand with this independent contractor analysis. The Fourth Circuit is going to look at a set of factors to determine, well, is this worker actually an employee or an independent contractor, as in, are they joint employers? So they came out with this test in 2017. It is a 6-factor list, but again, it's not an exhaustive list. They also are looking at the circumstances of the whole activity, of what actually, you know, the facts, boots on the ground kind of facts. That's what they're going to be looking at. Okay, next slide. So I'll just quickly go through these. And again, there's some overlap. So when you're looking at, when the Fourth Circuit is looking at these entities, or a situation where you have a staffing company and then the site that the individual is performing the work at, they're going to be looking at whether these two entities, if they both direct, control, or supervise the worker, whether by direct or indirect means, whether they are able to hire, fire, or modify the terms and conditions of the worker's employment. And I know, you know, there's situations that come up where, you know, the on-site company can basically say, no, we don't want to work with that person anymore, or no, we're not willing to do that anymore. They're going to modify this term or condition. So that is an important factor when you're looking at joint employment status. Okay, next slide. the degree of permanency and duration of the relationship between the entities. And that kind of goes into the next one, common control. You know, if you have a subsidiary that all your employees are employed through, but then you have a parent company, you have other affiliates, you know, there is common control there, and there's a degree of permanency in that relationship. So that's all going to lean towards joint employment. Whether the work is being performed on a premises owned or controlled by one or more of the putative joint employers. You know, if this employee is working in a building that's owned by the parent, but then they are employed through the subsidiary, you know, that's a factor that's looking like joint employment. Next slide. And then who is handling payroll, who's providing workers' comp, who's paying the payroll taxes, who's providing the equipment and the tools necessary to complete the work. And I know in several of these instances, you know, usually the staffing company, if you're working with the staffing company, is at least doing the payroll, the workers' comp, the payroll taxes, all those types of things. But again, the Fourth Circuit is going to be looking at all these factors and really all the factors taken together to really make a decision on whether these entities are joint employers. And so again, if they find that you are a joint employer, then you are going to be on the hook for all those benefits, just like the other joint employer. And so, you know, you can face all those same damages that Chris and I have already gone through, you know, back pay, the value of the benefits, all those types of things, if the Fourth Circuit found you're a joint employer. Okay, next slide. Okay, recommendations. So we recommend, of course, that you have an independent contractor agreement in place with all of your independent contractors. And so whether you're working with you know, like an individual business, or if you're working with a staffing company, you know, you're of course going to have an agreement in place with that staffing company as well. And this is going to show, again, courts and all these agencies can put an agreement aside, but this is going to tend to show that, you know, you've chosen to enter into a working relationship with these people as independent contractors. So it can also set forth the terms of the project. It's going to protect the company over disputes over any kind of terms of the project. You can be very specific in those agreements and lay out all the responsibilities of the independent contractor. And then, you know, what we would say, if we're on the, you know, the hiring side or the company side, the very limited responsibilities on the company side. And, you know, this can also help protect against misclassification if you have an agreement in place, assuming that you are actually complying with everything you say in the agreement, you know, that the true circumstances of the relationship are showing an independent contractor relationship. Okay, next slide. Chris, you want to take this?
Yeah. Okay. So terms of the independent contractor agreement. It needs to specifically state when the relationship begins and when it ends and how it ends. So typically this is going to need to be like a provision you're used to seeing in business agreements. This would be something along the lines of either party is permitted to end this agreement at any time with no notice. Either party is permitted to end this agreement with 30 days notice, or it could be singular to the obligation of the contractor only, where business is permitted to end agreement with no notice. Contractor must give 30 days notice, that sort of thing. And in a situation like this, you wouldn't necessarily state unless there was a requirement for advance notice from the company, you wouldn't necessarily state it. You would just have to say contractor must give company 30 days notice before ending the relationship, you know. So, but it needs to be clear. Don't have it automatically renewable. I see that, and that's a problem, right? Because that obviously indicates a sustained relationship. Define the services. There needs to be pretty early in the contract the specific services that are being provided needed to be defined with the clarity, and that'll be an opportunity for you to make sure that you're writing it in a way that it's going to align itself more with, this is not a skill set we have. This is not part of our business. You know, not actually saying that, right? Those are saying conclusions. I'm saying facts that fall into that analysis that would make the point that it's not the business of the company. It's not a skill set we have. It's not work that we're already doing. Then you obviously put in your normal provisions of no expectations of benefits or expense reimbursement. You've got to pay for all of your insurances, any fees, any licenses that are associated with you doing this business for us. You've got to pay any workers' compensation insurance that is going to cover the workers that you assign to this. You have got to pay any, you've got to have any business insurance that you're required to do this business, and you need to list us as an additional insured. And it needs to be up to this maximum amount of $2 million, workers' comp to $1 million, sort of requirements about insurance, requirements that the company's listed as additional insureds. This provision, the contracts will also say you've got to provide your tools, your equipment, and, you're responsible for your expenses. Next slide.
So payment for services, I think this is a big one. If you're paying people hourly, you're paying them on the same timetable as you pay employees, like weekly, bi-weekly. All of that is suggesting that they are an employee. So with independent contractors, it's better to do a one-time lump sum payment at the end of the project. Everything that in the agreement needs to reflect that this is project-based. This is not an ongoing relationship. Now, it can still be based on hours worked, but if so, pay it one lump sum at the end of the project. And we had a question too about someone that said, the staffing company, when they send the invoice, it'll have hours on it. And that's probably, I think that's fine. But if you have employees that are clocking in and out, they're filling out timesheets, they're being paid hourly, they're on your standard payroll practices, all of that leans employees. You need to require invoices for payment. So you need to say in the agreement, you will be paid such and such for your services after you submit, an invoice to us on the first day of the month or last day of the month, whenever you want to put in there. And then, just again, reiterating that you don't want to reflect that you're paying on a regular ongoing basis. Next slide.
So on that, about the pay, a lot of independent contractor relationships employers say, well, wait, they're expecting to get paid. They're expecting to get paid regularly. A lot of times we're dealing with someone who's working only for that business at the time. And in that scenario, at least you have the documentation of somebody providing an invoice with, it was these many hours worked. So in this agreement, then you're going to have something that talks about how is this employee paid? Well, this contractor, sorry, how are they paid? Well, this is somebody who provides these specialized services for $190 an hour, right? That's not unusual for a true independent contractor relationship. But if that's the case, then you realize we're talking about hourly, about the same way an employee would be paid that's a non-exempt employee. And so what we say in that scenario is, all right, then you need to submit invoices to us. And the way you control the time period to now not look like every week or every other week is every 15 days or every 10 days. You're starting to implement, you're treating it differently than you do your employees, and you're putting in some measures in place to allow them to get regular pay, but it still look like, you do what you can do as a company to protect yourself. And another thing you can do is, as we said, require the written invoices first. And then you turn around and you pay them in a certain amount of time. And you can outline that in your contract that invoices submitted will be paid by 30 days later, 15 days later. Again, don't make it look like it's, the same sort of time period that you would use. These are ways that you can buttress around a regular payment process. So that's important to think about if you can't do it by project or irregularly. Like you pay 1 month when they were here and then they don't come back for 2 more months, a true contractor. And, then you pay them then. Or you pay them at certain intervals. We're going to pay you this block, or we're going to pay you that block at intervals. And then on the end of the job, we'll give you this. Those look better and are easier to defend. We talked about the insurance. I already talked about that before. Make sure that you're being asked to be named as an additional insured, and particularly on any employee practices liability, insurance, commercial general liability, and workers' comp, right? Those are three that you're going to want to be able to claim statutory employer and invoke protection under their carrier's coverage. And then finally, an indemnification provision, an indemnification provision that specifically says this is an independent contractor relationship. And this independent contractor agrees to indemnify, hold harmless, and defend company for any claims that arise from the contractor's work, the quality of the work, provision of services, or claims brought by contractor's employees against the company, and then I would add it, or any third-party entities contending that, contractor is, responsible for any liabilities to the employees or for contractors' work. So, a really good indemnification provision that's going to protect the company in regards to any defective workmanship claims or any outcomes of that, as well as any employment-related claims made by the contractor's employees or the contractor considered the employee themselves. Next slide.
So what to do now? You should be auditing your current relationships, the agreements that you currently have in place. I will say, all of these, like I said, all of these agency rules and tests that we've been talking about, they are wanting to find employee status most of the time. They're wanting to find joint employment. And so you really need to be looking at, what do I have in place? What are my current relationships? And, send us your agreements. Let us take a look at them and make sure those protections are in place. The agreements can be ignored, like we've said, by the agencies, but you still want to make sure you have things like indemnification in there. You definitely still want an agreement in place. It's better to have it with an entity rather than an individual. That provides an extra layer of protection. There always needs to be a start and an end date. Again, not looking like this is an ongoing relationship. It shouldn't restrict other work or control terms and conditions of providing services that are typically aligned with an employment relationship. So, things like a non-compete, that's going to be a big red flag that makes you look like employment status. So independent contractors, just by their nature, usually can do work for others. And again, going back to making sure you have those strong indemnification provisions, and you can even require them to provide you proof that they are paying their taxes, so that the IRS doesn't come looking to you for that.
So I'm going to answer one of the questions that were submitted prior that was submitted by an anticipated attendee prior to the webinar today. How do we navigate gig workers from companies like blank, I'm not going to say the company, when it comes to injuries on the job? All right, so the answer to that is, this is exactly what we're talking about here. You have a contract with the company that is providing what I perceive are gig workers that may or may not be doing labor provisions, or, who knows what sort of work. This could be seen as temporary staffing. I'm not entirely sure, but the short of it is, your agreement is with the company providing the workers or with the gig worker. And it is specifically saying, we don't provide workers' comp. You do. You need to list us as an additional insured on the policy, and you need to insure us that it's valued at whatever value you want it should be, 1 million or more, usually. None of that matters, obviously, if this is somebody that you're considered a joint employer of, or if this is somebody who is not a real contractor, right? None of it matters. But if it is a true situation where it's either labor that's going to not be considered a joint employee of yours, i.e. it's not permanent, or not a contractor, then you shouldn't have to worry about your workers' comp having to step in and cover it. What's tough about is if there's a determination that this is actually, you are a joint employer, or this is an employee relationship, not a contractor relationship, then it's a situation where, if your carrier isn't going to cover it, you might be having to pay dollar for dollar. The second part of this question was, how do we maintain our workplace policies without making it seem like they're losing their contractor status and becoming employees? Well, you don't. The only policies that you're going to require that they follow, obviously, are the ones that are required by the industry, and the standards that are applicable to the work that this contractor is performing, or that if it's specific to your industry, the work that's applicable to your industry. Obviously, the exceptions to this that come to mind in any HR world would be, well, what about, Chris, you always tell us that we've got to make sure our vendors don't come onto premise and engage in harassment, discrimination of our employees. Well, that's true. That's true. And in that situation, you would say, we expect you to abide by all federal laws applicable to our employees. If there is anything that you want to include that it requires that, then you need to be putting in your independent contractor relationship or contract with them. You don't attach the actual employment policies. You instead put provisions in there that says vendor and or vendors staff agree to comply. They comply with these laws and they agree to maintain that compliance during their provision of services to our company. Great questions. Next slide. I don't know if we have any more. Good, that's our last one. So we've got time for the other question. This last question, I think, was the one Katie, oh, it's 1 o'clock, so if y'all need to go, go. But this was the last one I think Katie was tempting that she was trying to answer. And it's actually a pretty specific question. So, you know, the first thing we would say is, this is a question that is specific enough to where this would us be giving legal advice and counsel and not knowing any of the facts. So something we can't do. But the question is around whether someone who is a current employee who is going to retire and the company wants to use them as a consultant, they're anxious. They're worried about whether or not this is going to be considered a true independent contractor or consultant or an employee. And the questions that are asked are, we're going to have him complete a W-9. We're going to tell him he's a 1099. It's not going to be run through accounting or payroll. Those are all ministerial functions that have nothing to do with whether or not this person is actually going to be considered an employee, right? Ministerial functions, contracts mean nothing if the analysis of actually the work that's going to be doing under the criteria that we've provided today is not considered, right? So that's the analysis. Use the tool that Keely's sending. Use our slides. You truly can't need much more than these slides that Katie and I have put it together for y'all to make this analysis. And if you'll get a sense of whether or not this is something that's going to fly. You know, because even if you have somebody who's retiring, who's going to work on an as-needed basis, remember we talked about that part-time, full-time, as needed, that doesn't mean they're not an employee. So with that, I think, is there anything else, Katie, that's out there that we need to think about?
Nothing else for me.
All right, well, thanks for bearing with us. I know it sounded in our analysis of the factors that they were a little bit repetitive when we came down to our recommendations, and that would just tell you that our recommendations are based on the analysis of the factors that matter. So I hope you found it helpful. Next month, we're going to be talking about the new the wage rule, the exempt wage rule, oh my gosh, the Department of Labor's most recent guidance. Katie, help me with the words that I've just lost.
FLSA.
Thank you. Joseph Dickey's going to come and talk about that. I know a lot of us wanted to hear about that. It's current too. And so that's why he'll be covering that next month. Look for the blog and have a great time and a great remainder of your day. We'll be having our webinars through June. So look for the blogs on those when they come out as to what they are, and join us.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.